Namaskar, brothers and sisters, ladies and gentlemen, students, scholars, teachers, trainers, professors, professionals, official digital learners. I welcome all respected doctors and directors. I welcome all honorable ministers, managers. I welcome all honorable advocates, advertisers, institute advisors. It's a really nice time, nice place, nice section that we are describing, explaining our holy Indian identities and international laws with human rights. American Convention on Human Rights, 1969. What's the background of American Convention on Human Rights, 1969? The Bogota Charter of the Organization of American States, the American counterpart of the Council of Europe, was adopted by the Ninth Inter-American Conference in 1948. Besides establishing new institutions of the OAS in 1948, Bogota Conference also adopted the American Declaration on the Rights and Duties of Man. It is significant to note that this declaration was adopted 7 months before the adoption of the Universal Declaration of Human Rights. The main difference between the American Declaration and the Universal Declaration is that while the latter contained only rights, the former also contained articles on duties of man. In the American Declaration, while 28 articles proclaim the rights of man, 8 articles deal with the duties of man. As against this, of 30 articles of the Universal Declaration, only one article, namely Article 29, deals with duties of man. The preamble of the resolution, which embodied the American Declaration, stated that the affirmation of the essential human rights form the initial system of protection suited to the present social and judicial conditions. It also recognized the need to strengthen that system in the international field as conditions become more favorable. The Bogota Conference, which adopted the American Declaration of the Rights and Duties of Man, also requested the Inter-American Judicial Committee to prepare a statute for an American court to guarantee the rights of man. But the committee, instead of preparing the draft statute, recommended to the Judicial Council of the OAS that before purporting the draft statute, a convention on human rights should be adopted because that would involve a radical transformation of the constitutional system of American countries. Therefore, the 10th Conference of the American States simply advised the Judicial Council of the OAS to continue its studies on the jurisdictional aspects of the protection of human rights, with a view to analyze the possibility of the establishment of an inter-American Court of Human Rights. 5 years after the 10th Conference of the American States, the meeting of the consultation of the foreign minister decided that, keeping in view the progress achieved at the United Nations and in Europe in respect of the international protection of human rights, action in this field should also be initiated by American state with his objective in view. The meeting of the consultation of the foreign ministers established an Inter-American Commission on Human Rights and requested the Juridical Council to prepare draft convention on human rights and a statute of the Court of Human Rights. The Juridical Council accordingly prepared the draft convention on human rights. This draft was considered at the second Special Inter-American Conference in Rio de Janeiro in 1965. Two other drafts, the one submitted by Chile and the other by Uruguay, were also considered. The conference referred these drafts to the Council of the OES so that an acceptable draft could be evolved after hearing the view of the Commission of Human Rights. Meanwhile, another important development took place for the Inter-American Commission on Human Rights was empowered to receive and consider individual complaints of violation of certain basic human rights such as right to life and liberty, freedom of expression, right to a fair trial, equality before law, and freedom from religion. The Commission on Human Rights was formally recognized as a statutory organ of the OAS in the third Special Inter-American Conference held at Buenos Aires in 1967. By 1968, the Commission has prepared a draft convention on human rights. To adopt this convention, a special conference on human rights was called at San Jose, Costa Rica on 22nd November 1969. The conference finally adopted the American Convention on Human Rights. The convention came into force on July 11, 1978. Out of 32 members of the OAS, the convention had been ratified by 21 member states, but these 21 states do not include the United States. According to the preamble of the convention, the essential rights of man are based upon the attributes of human personality, are not upon one's being a national of a certain state, and therefore they justify international protection in the form of a convention, which should reinforce and complement the protection provided by the domestic law of the American states. Like the European Convention on Human Rights, the American Convention incorporates only civil and political rights. Right recognized under the Convention. The American Convention on Human Rights, 1969, guarantees the right to juridical personality, the right to life, the right to human treatment, freedom from slavery and involuntary servitude, right to personal liberty, right to a fair trial, freedom from ex facto laws, the right to compensation for miscarriage of justice, the right to privacy, freedom of conscience and religion, freedom of thought and expression, the right of reply, the right of assembly, freedom of association, right of family, the right to name, rights of the child, the right to nationality, the right to property, freedom of movement and residence, right to participate in government, the right of equal protection before law, and the right of judicial protection. Like the European Convention for the Protection of Human Rights and Fundamental Freedoms 1950, the American Convention also contained a non-discrimination provision by guaranteeing the free and full exercise of rights and freedoms recognized in the Convention without any discrimination on grounds of race, color, sex, religion, political or other opinion, national or social origin, economic status, birth or any other social condition. Yet, another similarity with its European counterpart is that under the American Convention, also the state parties have undertaken to achieve progressively the full realization of the rights implicit in the economic, social, educational, scientific and cultural standards set forth in the Charter of the Organization of American States. Besides this, like the European counterpart, the American Convention also permits the state parties to suspend rights and freedoms in times of war, in time of wars, public or other emergency that threatens the independence and security of a state party. During the period of such an emergency, the state party may thus avail the right of derogating from the obligation under the convention. But this is subject to the condition that the measures taken in derogation must not be inconsistent with other obligations under the international law and that no discrimination is made on the ground of race, color, sex, language, religion or social origin. Moreover, the state availing the right of derogation from the obligations under the convention is not permitted to suspend certain specified rights and freedoms, namely right to juridical personality Article 3, right to life Article 4, freedom from torture Article 5, freedom from slavery Article 6, freedom from ex post facto laws Article 9. Rights of the family Article 17, right to a name Article 18, rights of the child Article 19, right to nationality Article 20, and right to participation in government Article 23. In other words, these rights are regarded so fundamental that no derogation is permissible in respect of these rights. Lastly, a state party which avails the right of derogation is required to inform immediately the other state parties through the Secretary General of the OAS of the provisions it has suspended and application thereof and the date fixed for termination of such suspension. Implementation of the convention. The American Convention on Human Rights 1969 provides for two specialized enforcement mechanisms. One is Inter-American Commission of Human Rights, two is Inter-American Court of Human Rights. What is Inter-American Commission of Human Rights? The Commission is headquartered at the OAS in Washington, D.C. The Commission consists of 7 members who are persons of high moral character and recognized competence in the field of human rights. They are elected by the General Assembly of the OAS from a list of candidates nominated by the governments of the member states. They serve in their individual capacity and not as the representatives of their member states. The main functions of the Commission are to promote respect for observance of human rights. The functions of the Commission include developing on awareness of human rights among the peoples of state parties, receiving and considering petitions and other communications, and to submit annual report to the General Assembly of the OAS, requesting the government of the member states to furnish measures adopted by them to give effect to the convention, rendering of advisory opinions, making recommendations to the governments of member states to adopt progressive measures of human rights in their domestic law and constitutional provisions, and also to take appropriate measures to ensure observance of human rights and preparing studies and reports. The Commission may receive petitions from any person or group of persons or any non-governmental entity recognized in member states containing denunciations or complaints of violation of the Convention. It may also receive a complaint from a state party alleging that another state party has committed a violation of human rights set out in the Convention. But such a procedure is optional. This is subject to the condition that a state party which alleges that another state party is violating human rights recognized under the convention must have made a declaration recognizing the competence of the commission to receive such complaints, and the state party against which complaint is made must have also made a similar declaration. Moreover, a complaint is considered to be admissible only if it fulfills certain further conditions in the first place. Before making the complaint, domestic remedies must have been exhausted. Secondly, the complaint must have been made within 6 months of the date of the alleged violation was noticed for final judgment. Thirdly, a petition on the same subject must not have been pending before any other international procedure for settlement. Fourthly, the complaint or communication must not be anonymous or written in offensive language. Fifthly, it must not be the same complaint which was previously studied by the Commission. Sixthly and lastly, it must not be incompatible. It must not be incompatible with the provisions of this statute. The regulations are obviously unfounded or referring to events or situations having no bearing to a violation or disregard of human rights by the government against which it is made. After petition is received, the Commission may request the government concerned, that is, the state against which complaint is made, to furnish information within a reasonable period. After the receipt of the information, the Commission considers the complaint to take a decision as to whether grounds for the complaint exist. If it decides in negative, the matter is closed. In case, however, the decision is in affirmative, the Commission proceeds to examine the matter so as to verify the facts. For this purpose, the Commission may conduct an investigation and may also ask the states concerned to furnish all requisite facilities. The main object of the Commission is to secure a friendly settlement. If a friendly settlement is made, the Commission draws up a brief statement of the facts and the solution arrived at. In case such a friendly settlement is not made, the Commission draws up a report containing the facts and its conclusions. Then the report is transmitted to the states concerned. If within 3 months from the date of the transmission of the said report the matter is not settled or is not submitted to the court either by the Commission or the states concerned, the Commission may, by votes of an absolute majority of its members, draw up a report setting forth its opinion and conclusions on the question submitted for its consideration. The Commission may also make recommendations to the state party to take measures to remedy the situation within a prescribed period. The matter does not end here. After the expiry of said prescribed period, the Commission takes a decision by the votes of an absolute majority of its members as to whether the state concerned has taken adequate measures to remedy the situation. A pursuit of the above discussion shows that the Inter-American Commission on Human Rights performs two main functions. One, the general educative function, that is to develop an awareness of human rights among the peoples of America. And two is the administrative cum judicial function, namely to make recommendations to the governments of the member states to prepare studies and reports, requesting governments to furnish information, rendering advisory services, considering and deciding individual petitions, and to submit annual reports to the General Assembly. Inter-American Court of Human Rights, like the European Court of Human Rights, the Inter-American Court of Human Rights is not accessible to individuals. Again, like its European counterpart, the Inter-American Court is accessible only to the Inter-American Commission and to those state parties who have expressly recognized the jurisdiction. The Inter-American Court consists of 7 judges who are jurists of the highest moral authority of recognized competence in the field of human rights and are qualified for the appointment to the highest judicial office of the state. They ought to be nationals of the member states of the OAS and are elected in their individual capacity. But no two judges can be the nationals of the same state. They are elected for a period of 6 years and can be re-elected only once. The quorum of the court is 5 judges. The Commission has to appear in all cases brought before the court. Contentious jurisdiction. The court has two types of jurisdiction. One is the contentious and two is advisory. The contentious jurisdiction is optional. For availing this jurisdiction of the court, a state party, while ratifying or adhering to the convention, has to make a declaration recognizing as binding the jurisdiction of the court and on all matters concerning the interpretation or application of the convention. The powers of the court are much wider than its European counterpart. Cases before the court may result in order or compensatory damages, permanent or temporary, injunctive relief or both. If the court arrives at a decision that There has been a violation of the rights or freedoms recognized by the Convention. It can order that the injured party be ensured the enjoyment of his right or freedom that was violated, and in appropriate cases can order that violation of such right or freedom be remedied and fair compensation be given to the injured party. The state parties have undertaken to comply with the judgment of the court in any case to which they are parties. The judgment of the court is final and not subject to appeal. However, the court lacks the power to enforce its judgments and preliminary rulings and has to rely mainly on the OAS General Assembly. The court may submit annual report to the General Assembly of the OAS specifying the particular cases in which its judgments have not been complied with by state parties and may make its recommendations. The court has so far decided only a few cases. In Velasquez Rodriguez case, regarding the detention and disappearance of a Honduran student, the court decided that the Honduran government was responsible for violation of Article 4, 5 and 7 of the Convention, and therefore Honduras was liable to pay compensation to the student's family. Some of the main cases decided by Inter-American Court of Human Rights are: one is Barrios Altos massacre case, two is El Carcazú, Venezuela, three is Lev Valenson, Peru, four is the Last Temptation of Christ, Chile, five is Mapipan massacre, Colombia, six is Community of Mauana, Suriname, seven is Mac Chung, Guatemala, eight is La Nation, Costa Rica, nine is Plan de Sanchez massacre, Guatemala. Advisory jurisdiction: Inter-American Court of Human Rights possesses advisory jurisdiction also. Member states of the OAS or certain inter-American organs, including the Commission, may consult the court with regard to the interpretation of the Convention or other treaties relating to protection of human rights in the American states. At the request of any such state, the court may give advisory opinion regarding the compatibility of its domestic laws with such international instruments. Though the court decided only a few contentious cases, it has given some advisory opinions. It has given some important advisory opinions having important bearing upon the interpretation of the Convention. For example, in its advisory opinion on effect of reservations on entry into force of the American Convention, the Inter-American Court was requested to give its advisory opinion on the question: from what moment a state deemed to have become a party to the American Convention on Human Rights when it ratified or adheres to the Convention with one or more reservations. From the state of the deposit of instrument of ratification or adherence, or upon the termination of the period specified in Article 20 of the Vienna Convention on the Law of Treaties. While giving its advisory opinion, the court emphasized that modern rights treaties in general and the American Convention in particular are not multilateral treaties of the traditional type concluded to accomplish exchange of rights for the benefit of the contracting parties. Their object and purpose is the protection of the basic rights of individual human beings, irrespective of their nationality, both against the state of their nationality and all other contracting states. In concluding these human rights treaties, the states can be deemed to submit themselves to a legal order which they, for the common good, assume various obligations not in relation to other states but towards all individuals within their jurisdiction. The court further emphasized that the Convention, unlike other international human rights treaties, including the European Convention, confers on private parties the right to life, the right to file a petition with the Commission against any state as soon as it has been ratified the Convention. Article 44 of the Convention, by contrast, before one state may institute proceedings against another state, each of them must have accepted the Commission's jurisdiction to deal with interstate communications. Article 45. This structure indicates the overriding importance the Convention attaches to the commitments of state parties vis-à-vis individuals which can be rapidly implemented without intervention of any other state. In view of the above considerations, in view of the other observations, the court concluded that viewed in this light, and considering that the convention was designed to protect the basic rights of individual human beings, irrespective of their nationality, against states of their own nationality or any other state party. The convention must be seen for what in reality it is: multilateral legal instrument of framework enabling states to make binding unilateral commitments not to violate the human rights of individuals within their jurisdiction. The court finally held unanimously that the convention enters into force for a state which relieves all adheres to it with or without reservation on the date of the deposit of its instrument of ratification or adherence. Advisory opinion relating to interpretation of right to life. In its advisory opinion on restrictions to the death penalty, the Inter-American Court of Human Rights was requested by the Inter-American Commission to interpret Article 4, Right to Life of the Convention, invoking Article 64, 1 thereof, while rendering an advisory opinion. The court made, the court made certain observations about the advisory jurisdiction conferred on the court by the American Convention. The court observed that the advisory jurisdiction conferred on the court by Article 64 of the Convention is unique in contemporary, contemporary international law. Neither the International Court of Justice nor the European Court of Human Rights has been granted an extensive advisory jurisdiction which the Convention confers on the Inter-American Court. The Court emphasized that the Convention, by permitting member states and OAS organs to seek advisory opinions, creates a parallel system of that provided for under Article 62 and offers an alternative judicial method of a consultative nature, which is designed to assist states and organs to comply with and apply human rights treaties without subjecting them to the formalism and sanctions associated with the contingent of judicial process. It would therefore be inconsistent with the object and purpose of the Convention and the relevant individual provisions to adopt an interpretation of Article 64 that would apply to the jurisdictional requirements of Article 62 and thus rob it of its intended utility merely because of the possible existence of a dispute regarding the meaning of the provisions at issue in the request. Additional protocol to the American Convention on Human Rights in the area of economic, social, and cultural rights are Protocol of San Salvador, 1988. According to American Convention on Human Rights, 1969, any state party or commission may propose the protocol in the General Assembly for the consideration of state parties so as to include it slowly and gradually other rights and freedoms in the system. In the preamble of this additional protocol, state parties reaffirm their intention to consolidate in the American hemisphere within the framework of democratic institutions, a system of personal liberty and social justice based on respect for the essential rights of man. The state parties to the additional protocol recognize that the essential rights of man are not derived from one's being a national of a certain state, but are based upon attributes of human person for which they merit international protection in the form of a convention reinforcing or complementing the protection provided by the domestic law of American states. Further, bearing in mind although fundamental economic, social and cultural rights have been recognized in earlier international instruments of more broader regional scope, it is essential that rights be reaffirmed, developed, perfected, and protected in order to consolidate in America on the basis of full respect for the rights of the individual, the democratic representative form of government, as well as the right of its people to derive self-determination and the free disposal of their wealth and natural resources. Finally, considering that the American Convention on Human Rights provides that draft additional protocol to this convention may be submitted for consideration to the state parties, meeting together on the occasion of the General Assembly of the Organization of American States for the purpose of progressively incorporating other states and freedoms into the protected system thereof. State parties adopted the additional protocol to the American Convention on Human Rights, also known as Protocol of San Salvador. The main provisions of the additional protocol are: one is obligations to adopt measures. The state parties to this additional protocol to the American Convention on Human Rights undertake to adopt the necessary measures, both domestically and through international cooperation, especially economic and technical, to extend allowed by their resources and taking account their degree of development for the purpose of achieving progressively and pursuant to their internal legislations the full observance of the rights recognized in this protocol. Article 1. Obligation to enact domestic legislation. If the exercise of the rights set forth in this protocol is not already guaranteed by legislative or other provisions, the state parties undertake to adopt in accordance with their constitutional processes and the provisions of this protocol such legislative or other measures as may be necessary for making those rights a reality. Article 2. Obligation of non-discrimination. The state parties to this protocol undertake to guarantee the exercise of the rights set forth herein without discrimination of any kind for reasons related to race, color, sex, language, religion, political or other opinions, national or social origin, economic status, birth, or any other social condition. Rights mentioned or incorporated in the protocol. One is right to work. Everyone has the right to work, which includes the opportunity to secure the means of living a dignified and decent existence by performing a freely elected or accepted lawful activity, Article 6. Trade union rights. The state parties shall ensure the right of workers to organize trade unions and to join the union of their choice for the purpose of protecting and promoting their interests. As the extension of that right, the state parties shall permit trade unions to establish national federation or confederations or to affiliate with those that already exist, as well as to form international trade union organizations and to affiliate with that of their choice. The state parties shall also permit trade unions, federations, and confederations to function freely. No one may be compelled to belong to trade union. Article 8. Right to social security. Everyone shall have the right to social security protecting him from the consequence of old age and of disparity which prevents him physically or mentally from securing the means for a dignified and decent existence. In the event of the death of a beneficiary, social security benefits shall be applied to his dependents. Article 9. Right to health. Everyone shall have the right to health. Understood to mean the enjoyment of the highest level of physical, mental and social well-being. Article 10. Right to healthy environment. Everyone shall have the right to live in a healthy environment and to have access to basic public services. Further, the state parties shall promote the protection, preservation and improvement of the environment. Article 11. Right to food. Everyone has the right to adequate nutrition, which guarantees the possibility of enjoying the highest level of physical, emotional, and intellectual development. In order to promote the exercise of this right and eradicate malnutrition, state parties undertake to improve methods of production, supply, and distribution of food. And to this end, agree to promote greater international cooperation in support of relevant national policies. Right to education. Everyone has the right to education. The state parties to this protocol recognize that in order to achieve the full exercise of right to education, primary education should be compulsory and accessible to all without cost. Secondary education in its different forms, including technical and vocational secondary education, should be made generally available and accessible to all by every appropriate means, and in particular by the progressive introduction of free education. Higher education should be made equally accessible to all on the basis of individual capacity by every appropriate means, and in particular by the progressive introduction of free education. Basic education should be in place or intensified as far as possible for those persons who have not recessed or completed the whole cycle of primary education. Programs of special education should be established for the handicapped so as to provide special instruction and training to persons with physical disabilities or mental deficiencies. Article 13. Right to benefits of culture. The state parties to this protocol recognize the right of everyone to take part in the cultural and artistic life of the community, to enjoy the benefits of scientific and technical progress, to benefit from the protection of moral and material interest deriving from any scientific, literary, or artistic production of which he is the author. Article 14. Right to the formation and the protection of families. Everyone has the right to form a family, which shall be exercised in accordance with the provisions of the pertinent domestic legislation. Article 15. Rights of children. Every child, whatever his parentage, has the right to the protection that his status as a minor requires from his family, society, and the state. Every child has the right to grow under the protection and responsibility of his parents, save in exceptional judicially recognized circumstances. A child of young age ought not to be separated from the mother. Every child has the right to free and compulsory education, at least in the elementary phase, and to continue and his training at highest levels of the educational system. Article 16. Protection of the elderly. Everyone has the right to special protection in old age. Article 17. Protection of the handicapped. Everyone affected by the diminution of his and mental physical or mental capacity is entitled to receive special attention designed to help him achieve the greatest possible development of his personality. Article 18. Means of protection. Article 9 of the additional protocol provides that the state parties of this protocol undertake to submit periodic reports on the progressive measures they have taken to ensure respect for the rights set forth in this protocol. Further, all reports shall be submitted to the Secretary General of the OAS, who shall transmit them to the Inter-American Economic and Social Council and the Inter-American Council of Education, Science and Culture, so that they may examine them in accordance with the provisions of this article. The Secretary General shall send a copy of such reports to the Inter-American Commission on Human Rights. The Inter-American Commission on Human Rights may formulate such observations and recommendations as it deems pertinent concerning the status of the economic, social, and cultural rights established in the present protocol. In all or some of the state parties, which it may include in its annual report to the General Assembly or in a special report, whichever it considers appropriate. Protocol to the American Convention on Human Rights to abolish death penalty 1990. Article 1 of this protocol provides that the state parties to this protocol shall not apply the death penalty in their territory to any person subject to their jurisdiction. Article 2 further provides that no reservation may be made to this protocol. However, at the time of ratification or accession, the state parties to this instrument may declare that they reserve the right to apply the death penalty in wartime in accordance with international law for extremely serious crimes of a military nature. Inter American Convention to prevent and punish torture. 1985. Under Article 1 of the Convention, the state parties undertake to prevent and punish torture in accordance with the terms of this convention. Article 2 of the convention defines torture as any act internationally performed whereby physical or mental pain or suffering is inflicted on a person for the purpose of criminal investigation, as a means of intimidation, as personal punishment, as a preventive measure, as a penalty for or for any other purpose. Torture shall also be understood to be the use of methods upon a person intended to obliterate the personality of the victim or to diminish his physical or mental capacity, even if they do not cause physical pain or mental angers. However, the concept of torture shall not include physical or mental pain or suffering that is inherent in or solely the inconsequence of unlawful measures. Lawful measures provided that they do not include the performance of the acts or use of the methods referred to in this article. Persons to be held guilty of the crime of torture. According to Article 3 of the Convention, the following shall be guilty of the crime of torture: a public servant or employee who, acting in that capacity, orders, investigates, or induces the use of torture, or who directly commits it, or who, being able to prevent it, fails to do so. A person who at the invest a person who at the instigation of a public servant or employee mentioned in subparagraph A orders, invest, instigates or induces the use of torture, directly commits it, or is an accomplice thereto. No exemption for the plea of orders of a superior. Article 4 provides that the fact of having acted upon the fact of having acted under orders of a superior shall not provide exemption from the cases pending criminal liability. Other grounds not be invoked as justification of the crime of torture. According to Article 5, the existence of circumstances such as a state of war, threat of war, state of siege or of emergency, domestic disturbance or strife, suspension of constitutional guarantee, domestic political instability, or other public emergencies or disasters shall not be invoked or admitted as justification for the crime of torture. Further, neither the dangerous character of the detainee or prisoner, nor the lack of security of the prison establishment or penitentiary shall justify torture. Obligation of state parties to take effective measures. In accordance with the terms of Article 1, the state parties shall take effective measures to prevent and punish torture within their jurisdiction. Article 6. Further, the state parties shall guarantee that any person making an accusation of having been subjected to torture within their jurisdiction shall have the right to an impartial examination of his case. Article 8. Compensation for victims of torture. The state parties undertake to incorporate into their national laws regulations guaranteeing suitable compensation for victims of torture. Article 9. Extradition for persons accused of having committed the crime of torture. The state parties shall take necessary steps to extradite anyone accused of having committed the crime of torture or sentenced for commission of that crime in accordance with their respective national laws on extradition and their international commitments on this matter. Article 11. Necessary steps to establish jurisdiction. Article 12 of the Convention provides that every state party shall take the necessary measures to establish its jurisdiction over the crime described in this convention in the cases. One is when torture has been committed within its jurisdiction. Two is when the alleged criminal is a national of the state, or three is when the victim is a national of that state and it so deems appropriate. Every state party shall also take the necessary measures to establish its jurisdiction over the crime described in this convention when the alleged criminal is within the area under its jurisdiction and it is not appropriate to extradite him in accordance with Article 11, Article 12. Crime of torture deemed to be included in extradition treaty. The crime of extradition shall be deemed to be included among the extraditable crimes in every extradition treaty entered into between state parties. The state parties undertake to include the crime of torture as an extraditable offense in every extradition treaty to be concluded between them. Article 13. When a state party does not grant the extradition, the case ought to be submitted to its competent authorities as of the crime had been committed within its jurisdiction for the purposes of investigation and when appropriate for criminal action in accordance with its national law. Any decision adopted by these authorities shall be communicated to the state that has requested the extradition. Article 14. African Charter on Human and People's Rights 1981. African Charter on Human and People's Rights, also popularly known as Banjul Charter, was adopted on June 27, 1981 and entered into force on October 1986. So far as 49 states of the 50 members of the Organization of African Unity (OAU) and ratified or acceded to it. The only state which has not so far ratified or acceded to the African Charter is Sahrawi Arab Democratic. A special feature of the African Charter is that, along with rights, it also lays down the duties of the individuals. As noted earlier, even the American Convention contained an article entitled Relationship between Duties and Rights, but the difference is whereas the American Convention did so very briefly or even casually, the African Charter enumerates the duties in detail, laying greater emphasis on the duties of the individuals. This is evident from the preamble of the African Charter. Preamble. What is preamble? Through the preamble, the state parties, being the member of the OAU, recognize on the one hand that fundamental human rights stem from the attributes of human beings, which justifies their international protection, and on other hand that the reality and respect of people's rights should necessarily guarantee human rights, emphasizing the duties. The preamble states that the enjoyment of rights and freedoms also implies the performance of duties on the part of everyone. The preamble also the right to development, the right to development, the right to development, and that civil and political rights cannot be dissociated from economic, social, and cultural rights in their conception, as well as universality, and that the satisfaction of economic, social, and cultural rights is a guarantee for the enjoyment of civil and political rights. Human and People's Rights, Chapter 1 of Part 1 of the African Charter contains one is equality before law, two is right to respect for life and integrity of person, three is right to the respect of the dignity inherent in a human being and the recognition of his legal status. Four is right to liberty and security of person. Five is right to have his cause heard, right to have his cause heard, including right to appeal to competent national organs against violations of fundamental rights, right to presumption of innocence until proved guilty, right to defense, and the right to fair trial within a reasonable time by an impartial court or tribunal, Article 7. Freedom of conscience, the profession and free practice of religion, Article 8. Right to inform, Article 9. Right to free association, Article 10. Right to assemble free by with others, Article 11. Right to freedom of movement and residence, Article 12. Right to participate freely in the government of the country, Article 13. Right to property, Article 14. Right to work under equitable and satisfactory conditions, Article 15. Right to enjoy a state of physical and mental health, Article 16. Right to education and take part freely in the cultural life of community, Article 17. Family to be natural unit and basis of society and shall be protected by the state, Article 18. Article 2. Equality and prohibition of domination of a people by another, Article 19. Right to existence including the unquestionable and inalienable right to self-determination, Article 20. Right to freely dispose of wealth and natural resources, Article 21. Right to economic, social and cultural development, Article 22, Para 1. Right to development, Article 22, Para 2. Right to national and international peace and security, Article 23. Right to general satisfactory environment favorable to their development, Article 24. The African Charter provides that the member states of the OAU parties to the present charter shall recognize the rights, duties and freedoms enshrined in the charter and shall undertake to adopt legislative or other measures to give effect to them. Article 1. The charter also contains guarantee of non-discrimination. It provides that every individual shall be entitled to the enjoyment of the rights and freedoms recognized and guaranteed in the present charter without distinction of any kind, such as race, ethnic group, color, sex, language, religion, political or any other opinion, national and social origin. Fortune, birth or other status. Article 2. Further, the state parties to the present charter shall have the duty to guarantee the independence of the courts and shall allow the establishment and improvement of appropriate national institutions entrusted with the promotion and protection of the rights and freedoms guaranteed by the present charter, Article 26. Duties, Chapter 2 of the Part 1 of the African Charter lays down following duties of each individual. One is duties towards family and society, the state and other legally recognized communities and international community, Article 27, Para 1. Two is each individual to exercise the rights and freedoms with due regard to the rights of others, collective security, morality and common interest, Article 27, Para 2. He is duty to respect and consider his fellow beings without discrimination and to maintain relations aimed at promoting, safeguarding and reinforcing mutual respect and tolerance, Article 28. For his duty to preserve the harmonious development of the family and to work for the cohesion and respect of the family, to respect his parents at all times, to maintain them in case of need, Article 29, Para 1. 5 is duty to serve his national community by placing his physical and intellectual abilities at its service, Article 29, Para 2. 6 is duty not to compromise the security of state whose national or resident he is, Article 29, Para 3. 7 is duty to preserve and strengthen social and national solidarity, particularly when the latter is threatened, Article 29, Para 4. It is duty to preserve and strengthen the national independence and the territorial integrity of his country and to contribute to its defense in accordance with the law, Article 29, Para 5. 9 is duty to work to the best of his abilities and competence to pay taxes imposed by law in the interest of the society, Article 29, Para 6. 10 is duty to preserve and strengthen positive African cultural values in his relation with other members of the society in the spirit of tolerance, dialogue, and consultation, and in general to contribute to the promotion of the moral well being of society. Article 29, Para 7. 11 is duty to contribute to the best of his abilities to all times and at all levels to the promotion and achievement of African unity. Article 29, Para 8. African Commission on Human and People's Rights. Article 30 of the African Charter provides for the establishment within the OAU an African Commission on Human and People's Rights as the mechanism to promote human and people's rights and ensure their protection in Africa. The Commission consists of 11 members who are chosen from amongst African personalities of the highest reputation known for their high morality, integrity, impartiality, and competence in matters concerning human and people's rights. Preference being given to persons having legal experience they serve in their personal capacity. 12 is there is also provision for the appointment of secretary to the commission to be appointed by the Secretary General of the Organization of African Unity. His main function is to provide for the staff and services necessary for the effective discharge of the duties of the Commission. The functions of the Commission are to promote human and people's rights and in particular to collect documents, undertake studies and researches, organize seminars, symposia, and conference, disseminate information, encourage national and local institutions concerned with human and people's rights, and also, in case of need, give its views or to make recommendation to governments of state parties to the present convention. B is to formulate and lay down principles and rules aimed at solving legal problems concerning human and people's rights and fundamental freedoms upon which African governments may base their legislation and to cooperate with other African and international institutions concerned with the promotion and protection of human and people's rights. To ensure the protection of human and people's rights, to interpret all the provisions of the Charter at the request of a state party, institutions of the OAU or an African organization recognized by the OAU, to perform any other task which may be entrusted to it by the Assembly of Heads of States and Governments. Implementation of the African Charter. The African Charter provides mainly three main procedures. One is the reporting procedure, two is interstate communication, three is communication other than those of state parties, including concluding individuals for the implementation of the provisions of the convention and the main machinery for implementation is the commission. Reporting procedure. State parties to the African Charter have undertaken to submit every 2 years, beginning from the date of the Charter enters into force, a report on the legislative or other measures they may have taken to give effect to the rights and freedoms recognized and guaranteed under the Charter. Interstate communication. The African Charter provides that if a state party has good reasons to believe that another state party has violated the provisions of the Charter, it may bring the same to the notice of the state in writing. A communication to the same effect shall also be sent to the Secretary General of the OAV and to the Chairman of the Commission. The state party concerned against whom the shared communication is required to send a written explanation. If the matter is not settled to the satisfaction of the two state parties concerned bilaterally or through other peaceful procedure within 3 months from which the complaint was originally made, either state will be entitled to refer the matter to the Commission through the chairman notifying the other state concerned. Further, in case the state party considers that another state party is guilty of the violation of the provisions of the African Charter, it need not follow the above procedure and may refer the matter directly to the Commission through the chairman to the Secretary General of the OAU and the states concerned. The Commission may ask the states concerned to submit all relevant information relating to the matter. The states concerned are permitted representation when their matter is being considered and may take written or oral representation. It may be noted here that before dealing with the matter, the Commission satisfies itself that before the complaint has been made, all local remedies have been exhausted. However, the Commission may exempt from this requirement if it finds that the procedure of exhausting the said remedies would be unduly prolonged. After making all efforts to reach an amicable settlement based on respect of human and people's rights, the Commission within a reasonable period is required to draw a report containing the facts and its findings and transmit the report to the states concerned and communicate the same to the Assembly of Heads and governments will such recommendation which it deems useful for it. If one or more communications reveal the existence of a serious or massive violation of human and people's rights, the matter is taken seriously and it shall bring the same to the nation of notice of the Assembly of Heads of States and Governments, which may in its turn ask the Commission to make as an in-depth study of the said cases and submit a factual report including its findings and recommendations. Other communications, including individuals, African Charter provides that the Secretary of the Commission shall make a list of communications other than those of state parties before each session and transmit the same to the members of the Commission, who shall decide by a simple majority of the members as to which communication ought to be considered by the Commission. Though this provision does not expressly mention individuals. Obviously, individuals' communications are included in the term communication other than those of the state's party. It is further provided that communication relating to human and people's rights referred to in Article 55 received by the Commission shall be considered if they: 1 is indicate their authors even if the latter requests anonymity. 2 is are compatible with the Organization of African Unity or with the present charter. 3 are not written in disparaging or insulting language directed against the state concerned and its institution or to the OAU. 4 are not based exclusively on news disseminated through the mass media. 5 are sent after existing local remedies, if any, unless it is obvious that this procedure is unduly prolonged. 6 are submitted within a reasonable period from the time local remedies are exhausted from the state. The Commission is seized with the matter. And 7 lastly, they do not deal with cases which have been settled by the states involved in accordance with the principles of the Charter of the OAV or the provisions of the present Charter. The Commission submits report of all its activities to the Assembly of the heads of states and government. All measures taken by the Commission remain confidential until such a time as the Assembly of Heads of States and the government otherwise decide. After considering the report by Assembly of Heads of States and Governments, the chairman gets the report published appraisal. A special feature of the African Charter which distinguishes this regional convention from other regional conventions in the enumeration of duties in detail. Liberty is a social contract. If a person wants to enjoy his rights, he will have to respect the right of others. Every right has a corresponding duty. Enumeration of duties is therefore a welcome feature. Unfortunately, the African Charter does not take the matter to its logical conclusion. After enumeration of the duties, it stops there and does not provide for the enforcement of duties in case of breach. While providing for the implementation of the provisions of the Convention, no provision whatsoever is made for the enforcement of duties. Even the functions of the Commission are conspicuous of any mention of the enforcement of duties. Thus, the provisions relating to duties are simply figurative or decorative, lacking any substance. The only provision, Article 1, obligating state parties to recognize duties is to adopt legislative or other measures to give effect to them, but this is far from being effective. Yet another deficiency or the point which distinguishes it from the European and American convention is that the African Charter has not established any court for the enforcement of human and people's rights, thereby relying heavily on mediation, conciliation, and arbitration, which are considered more in keeping with the traditional African dispute resolution system. The Commission, as the main mechanism for the implementation of the provisions of the African Charter, only performs essentially on fact finding and information providing role. The Commission can simply investigate and submit to the Assembly of Heads and Governments report on human rights violation. It can neither take a binding decision nor can it enforce it. It is only the OAU Assembly which can decide and take necessary action. Both interstate and indigenous communications are accepted upon ratification of the African Charter. Last but not the least, African Charter on Human and People's Rights is the international or regional convention on human rights which specifically enumerates and protects people's rights. Other regional arrangements for the protection of human rights. Following are some of the other regional arrangements for the protection of human rights. One is Helsinki Act, final act of the Conference on Security and Cooperation in Europe 1975. Two is the Arab Commission on Human Rights. Next topic is National Protection of Human Rights. Human Rights and Indian Constitution. The Indian Constitution bears the impact of the Universal Declaration of Human Rights, and this has been recognized by the Supreme Court of India. While referring to the fundamental rights contained in Part 3 of the Constitution, Sikri CJ of the Supreme Court in Keshwaran Bharti versus State of Kerala observed, I am unable to hold these provisions how that rights are not natural or inalienable rights. As a matter of fact, India was a party to the Universal Declaration of Rights, and that declaration describes some fundamental rights as inalienable. Earlier in Golab Nath versus State of Punjab, the Supreme Court observed fundamental rights are the modern name for what have been traditionally known as natural rights. The Supreme Court has also recognized the interpretative value of the Universal Declaration of Human Rights. The Universal Declaration of Human Rights does not define the term human rights. It refers them as the equal and inalienable rights of all members of the human family. The framers of the Indian Constitution were influenced by the concept of human rights and guaranteed most of human rights contained in the Universal Declaration. The Universal Declaration of Human Rights contains civil and political as well as economic, social and cultural rights. While civil and political rights have been incorporated in Part 3 of Indian Constitution, economic, social and cultural rights have been incorporated in Part 4 of the Constitution. The following chart is being given below it to indicate the human rights which have been incorporated in Indian Constitution. National Protection of Human Rights 2. Under Protection of Human Rights Act, what is in its introduction? India decided to establish a National Commission of Human Rights for the redressal of grievances of human rights violation. On 28 September 1993, the President of India promulgated an ordinance which established a National Commission of Human Rights. Thereafter, a bill on human rights was passed in the Lok Sabha on December 18, 1993 to replace the ordinance earlier promulgated by the President. This bill received the assent of the President on January 8, 1994 and was published in the Gazette of India, Extraordinary Part 2, Section 1 on January 10, 1994. Thus, the Protection of Human Rights Act number 10 of 1994 came into force. But since the National Commission of Human Rights has already been established and certain acts in pursuance of the ordinance had already been performed, Article 1(3) provided that the Act shall be deemed to have come into force on the 28th day of December 1993. Section 1(2) provides that the Act extends to the whole of India. The preamble of the Act makes it clear that it is an act to provide for the constitution of National Human Rights Commission, commissioned in states and human rights courts for better protection of human rights and for matters connected therewith or incidental thereto. Definition of human rights under the Act. Section 2D of the Act defines human rights as the rights relating to life, liberty, equality and dignity of the individual guaranteed by the Constitution or embodied in the international covenants and enforceable by courts in India. Thus, for the purposes of the Act, human rights are rights relating to life, liberty, equality and dignity of the individual guaranteed in the Constitution or embodied in the international covenants and enforceable by courts in India. Thus, the Act gives a very narrow definition of human rights and does not even include all the fundamental rights guaranteed by the Constitution. It simply includes the fundamental rights relating to the life, liberty, equality and dignity guaranteed in the Constitution or embodied in international covenants on human rights and enforceable in India. For example, it does not include fundamental rights of prohibition of employment of children in factories, etc. Article 25. Protection of interest of minorities. Article 29. Right of minorities to establish and administer educational institutions as regards the words embodied in the international covenants and enforceable by courts in India. They certainly widen the scope of human rights, fundamental rights enforceable by courts in India. As pointed out in the preceding chapter, human rights enforceable by the court in India can be divided into three categories. One is enumerated fundamental rights. Two is other fundamental rights. Three is unenumerated rights. The term enumerated fundamental rights means the human rights embodied in the international covenants on human rights, especially the international covenants on civil and political rights, and which are specified as fundamental rights in Part 3 of the Constitution. The term other fundamental rights means the human rights embodied in the international covenants and recognized as fundamental rights by courts in India, even though they have not been specified as fundamental rights in Part 3 of the Constitution, such as the right to privacy, right to travel abroad, right to compensation, etc. These have been discussed in detail in earlier chapters. The term unenumerated rights means the human rights which have been enumerated in the international covenants but are neither enumerated as fundamental rights in the Constitution nor have been so far recognized as fundamental rights as courts in India. One may, however, add that even unenumerated rights may in future be recognized as fundamental rights in a particular case. For example, in Vishaka versus State of Rajasthan, the three-judge bench of the Supreme Court has recognized the right of gender equality and guarantee against sexual harassment and abuse of working women at their workplaces as emanating from Article 14. But when such a right is recognized as a fundamental right emanating from existing or specified fundamental rights, it ceases to be in the category of unenumerated rights and comes in the second category of rights, namely other fundamental rights. But before such a right is included in the definition of human rights, a condition precedent is that it must be embodied in the international covenants, since Section 2F defines international covenants as the International Covenants on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights adopted by the General Assembly of the United Nations on 16 December 1966. The said right must be embodied in these two international covenants and not in any other international covenant on human rights for the purpose of definition of human rights as given under Protection of Human Rights Act 1993, Act number 10 of 1994. In T. Valian versus the Registrar, State Human Rights Commission, Chennai, the question for consideration before the court was whether right to property is included in the definition of human rights under the Act. The Madras High Court held that the definition of human rights under the Act cannot be extended to the right to property also. Moreso, when the legislature had explicitly omitted right to property within the said definition. Similarly, the right to work cannot be included in the definition of human rights. This has been same footing as to right to livelihood. Though the apex court has observed the right to work becomes as much fundamental as right to life that would be once a person is appointed. The High Court referred to the observation of the Supreme Court in Air India Statutory Corporation versus United Labour Union and further observed that the observation must be considered in tune what is set out in paragraph 15 of the judgment. So, reading it would mean that the right to work as fundamental right can only be considered as fundamental right in those cases where there is a legislative guarantee in the form of legislation. In the absence of right to work being fundamental right, it would not fall within the expression life under Article 21 and it so would not fall within the definition of human rights as set out under Section 2D of the Act on this court also. The Act of the Commission would be without jurisdiction. Reference may also be made here to the full bench case of the apex court, namely MSG Telefilms Limited versus Union of India. The Supreme Court observed that the promotion of human development and the preservation and protection of human rights proceed from a common platform. Both reflect the commitment of the people to promote the freedom, the well-being and dignity of individuals in society. Human development as a human right has a direct nexus with the increase in capabilities of human beings as also the range of things they can do. Human development is eventually in the interest of society and on a larger canvas. It is in the national interest also. Progress and development in all fields will not only give a boost to the economy of the country but also result in living conditions for the people of India. Even a hybrid body is bound to protect human rights as it cannot be violated even by such a body. The Board of Control for Cricket in India (BCCI), which has the pervasive control over the entire support of cricket, including the participants as well as spectators, cannot apparently act in violation of human rights. Further, in our constitutional scheme, rule of law would by all means prevail over rule of cricket. A body regulating the game of cricket would be compelled by the court to abide by rule of law. The Supreme Court concluded that the law requires to be expanded in this field and it must be held the board answerable. The description of other authorities as contained in Article 12 of the Constitution of India and satisfies the requisite legal test. It would therefore be a state. Giving the reason for this conclusion, the apex court observed that the board discharges a public function. It has its duties towards the public. The public at large will look forward to the board for selection of the best team to represent the country. It must manage its housekeeping in such a manner so as to fulfill the hopes and aspirations of millions. It has thus a duty to act fairly. It cannot act arbitrarily, whimsically, or capriciously. Public interest is thus involved in the activities of the world. It is thus a state actor. It is thus a state actor in PI Money Child, Canada Reddy versus Obama and others. The Supreme Court held that there is another aspect which cannot be lost sight of. The right of property is now considered to be not only a constitutional or statutory right but also a human right. Further, in Tukaram Kannajoshi versus Maharashtra Industrial Development Corporation, the Supreme Court has recently held that the right to property is now considered to be not only a statutory right but also a human right, though it is not a basic feature of the constitutional or fundamental right. Human rights are considered to be in the realm of individual rights, such as the right to health, the right to livelihood, the right to shelter and employment, etc. Now, however, human rights are gaining an even greater multifaceted dimension. The right to property is considered very much to be a part of such new dimension. In the case at hand, there has been no acquisition. The question that emerges for consideration is whether in a democratic body polity, which is supposedly governed by the rule of law, the state should be allowed to deprive a citizen of his property without adhering to the law. The matter would have been different had the state pleaded that it has rights, title and interest over the shared land. It, however, concedes to the right, title and interest of the appellants over such land and pleads the doctrine of delay and laches as grounds for the dismissal of the petition or appeal. Further, a question then arises with respect to the authority or power under which the state entered upon the land. It is evident that the act of state amounts to encroachment in exercise of absolute power, which in common Parlance is also called the use of power or use of muscle power. The power, the further clarity, this position, it must be noted that the authorities have treated the landowner as a subject of medieval India, but not as a citizen under our constitution. The state, especially a welfare state, which is governed by the rule of law, cannot arrogate itself to a status beyond one that is provided by the constitution. Our constitution is an organic and flexible one. Delay and latches is adopted as a mode of discretion to decline exercise of jurisdiction to grant relief. There is another facet. The court is required to exercise judicial discretion. The said discretion is dependent on facts and circumstances of the cases. Delay and latches is one of the facets to deny exercise of discretion. It is not an absolute impediment. There can be mitigating factors, continuity of cause of action, etc. That apart, if the whole thing shocks the judicial conscience, then the court should exercise the discretion more so when no third party interest is involved. Thus analyzed, the petition is not hit by the doctrine of delay and laches, as the same is not a constitutional limitation. The cause of action is continuous and further obstruction certainly shocks judicial conscience. Lastly, depriving the appellants of their immovable properties was a clear violation of Article 21 of the Constitution. In a welfare state, statutory authorities are bound not only to pay adequate compensation, but there is also legal obligation upon them to rehabilitate such persons. The non-fulfillment of their obligation would tantamount to forcing the said uprooted persons to become vagabonds or to indulge in anti-national activities as such sentiments would be born in them on account of such ill treatment. Therefore, it is not permissible for any welfare state to uproot a person and deprive him of his fundamental or human rights under the grab of industrial development. In a case, the Supreme Court has held that domestic violence is also a matter of human rights. Besides this, in National Legal Services Authorities versus Union of India, the Supreme Court has held that human right is a moral and prior legal right. It has not been given by people, nor can it be withdrawn by them. However, it may be noted that human rights are rights of human concerning to their life, liberty, equality and dignity. The term human right would therefore not apply to individual rights of parties, even against the state arising under a contract. This has been held by Bombay High Court in Maharashtra Housing and Development Authority versus Maharashtra State Human Rights Commission. Amendment of Section 2, the Protection of Human Rights Amendment Act 2019 has made in Section 2, in subsection 1, after clause B, the following clause shall be inserted, namely, be a Chief Commissioner means the Chief Commissioner for person with disabilities referred to in subsection 1 of the section 74 of the Rights of Persons with Disabilities Act 2016. In section 2 after clause G, the following clause shall be inserted, namely, National Commission for Background Classes means the National Commission for Background Classes constituted under Section 3 of the National Commission for Backward Classes Act 1993. In Section 2, in subsection 1, after clause, the following clause shall be inserted, namely, National Commission for Protection of Child Rights means the National Commission for Protection of Child Rights constituted under Section 3 of the Commissions for Protection of Child Rights Act 2005. Amendment of a Section 3. In Section 3 of the Principal Act, in Section 2, one is in Section 2, one is in Clause A, for the words Chief Justice, the words Chief Justice of India or a judge shall be substituted. 2 is in Clause B, in Clause D, for the words two members, the words three members, out of which at least one shall be a woman, shall be substituted. B is in subsection 3. One is for the words the National Commission for Minorities, the words the National Commission for Backward Classes, the National Commission for Minorities, the National Commission for Protection of Child Rights shall be substituted. 2 is for the words and the National Commission for Women, the words the National Commission for Women and the Chief Commissioner for Persons with Disabilities shall be substituted. In subsection 4, for the portion beginning with shall exercise such powers and discharge such functions and ending with as the case may be, the following shall be substituted, shall subject to control of chairperson mainly exercise all administrative and financial powers except judicial functions and the power to make regulations under section 40B. A pursuit of the above provisions indicates that as regards the appointment of chairperson, previously only a person who had been the Chief Justice of Supreme Court of India could be appointed, but with the above amendment, besides the Chief Justice of India, says Chief Justice of Supreme Court of India, a person who had been a judge of Supreme Court of India can be appointed. As regards other provisions apart from National Commission of Minorities, National Commission for Backward Classes, National Commission for Women, National Commission for Protection of Child Rights have been incorporated by mention of these. The scope of the above provisions have been widened. National Human Rights Commission. What is Constitution? The National Human Rights Commission is constituted by the central government to exercise the powers conferred upon and to perform the function assigned to it under the Act. The Commission consists of a person, one is a chairperson who has been the Chief Justice of the Supreme Court. 2 is one member who is or has been the judge of the Supreme Court. 3 is one member who is or has been the Chief Justice of a High Court. 4 is two members to be appointed amongst persons having knowledge of or practical experience in matters relating to human rights. Besides this, the chairperson of National Commission for Minorities, the National Commission for the Scheduled Caste and Scheduled Tribes and the National Commission for Women shall be deemed to be members of the Commission for the discharge of functions specified in clauses B to Z of Section 12. The Act also makes provision for the Secretary General, who shall be the Chief Executive Officer of the Commission, and shall exercise such powers and discharge such functions of the Commission as it may delegate to him. As pointed out by the Supreme Court in Paramjit Kaur versus State of Punjab, the chairman of the commission, in his capacity as a judge of the High Court and then as a judge of the Supreme Court, and also as Chief Justice of India, and so also two other members who have held high judicial offices as Chief Justice of High Courts have throughout their tenure considered, expounded, and enforced the fundamental rights and are, in their own way, experts in the field. The Commission is truly an expert body to which a reference can be made by the Supreme Court under Article 32, and once such a reference has been made, no prohibition under the Protection of Human Rights Act will affect the jurisdiction of the Commission to investigate a case referred to it by the Supreme Court. Reference may be made here to People's Union for Civil Liberties versus Union of India. In this case, appointment of a retired police officer who had held the post of Director, CBI and Vice President Asia Interpol. As member of National Human Rights Commission had been challenged through a writ petition. The appointment had been challenged on the ground that there was public perception that personnel in police force are biggest violator of human rights. The Supreme Court observed that we certainly feel that these remarks cannot be so generalized as to make every personnel of the force, constituting nearly 2.2 million people, violators of human rights solely on the grounds that out of thousands of cases investigated and handled by them, in some cases the personnel involved have indulged in violation of human rights. It was also contended by the petitioner that the judgments apart the public perception of Indian police force as a whole is so poor that it considers to police as an organization to be violator of human rights. Therefore, selecting a retired police officer as a member of the commission would lead to erosion of confidence of the people in the commission. The Supreme Court observed that it is sincerely unable to gauge this public perception or its magnitude so as to import this concept on institutional basis. Further, public displeasure as presently perceived is not confined to the police force only. The views expressed in the media, the views expressed in the media very often show that the displeasure is reflected against many a department of the government, including constitutional bodies, and if public displeasure or perception were to be the yardstick to exclude people from holding constitutional or statutory offices, then many such posts in the country may have to be kept vacant. Then again, what is the yardstick to measure public perception? Admittedly, there is no barometer to gauge the perception of the people. In a democracy, people get elected by thumping majority to high legislative officials. Many a times public perception of a class of society in regard to such people may be that they are not desirable to hold such posts, but can such a public opinion deprive such people from occupying constitutional or statutory offices without there being a law to the contrary? There is a vast qualitative difference between public prejudice and judicial condemnation of an institution based on public perception, at any rate, as stated above. Public perception or public opinion has no role to play in selection of an otherwise eligible person becoming a member of the Commission under the Act. Finally, the fact that the Constitution of NHRC is covered by an Act of the Indian Parliament to an no UN General Assembly resolution can override the express provisions of the Act. Headquarters of the Commission. The headquarters of the National Human Rights Commission NHRC is located at Delhi. The Commission may, however, with the previous approval of the central government, establish offices at other places in India. The Commission shall ordinarily hold its meetings and sittings in its offices located at Delhi. However, it may, in its discretion, hold its meeting at any other place in India if it considers it necessary and expedient. The Commission or some of the members may transact businesses of places outside its headquarters as and when previously approved by the chairperson, provided that if the parties are to be heard in connection with an inquiry under the Act, at least two members shall constitute the bench of the Commission for such purpose. Appointment of chairperson and other members. The chairperson and other members are appointed by the President by warrant under his hand and seal after obtaining the recommendation of committee consisting of one is Prime Minister as a chairperson, two is Speaker of the House of People as a member, three is Minister in charge of Ministry of Home Affairs in the Government of India, member as a member. 3. 4 is Leader of the Opposition in the House of the People as a member. 5 is Leader of the Opposition in the Council of States as a member. 6 is Deputy Chairperson of the Council of States as a member. Provided further that no sitting judge of the Supreme Court or sitting Chief Justice of a High Court shall be appointed except after consultation with the Chief Justice of India. It is further provided that no appointment of a chairperson or a member shall be invalid by this reason of any vacancy in the above committee headed by the Prime Minister. Term of office of members. A person appointed as chairperson shall hold office for a term of 5 years from the date on which he enters upon his office or until he attains the age of 70 years. Whichever is earlier, a person appointed as a member shall also hold office for a term of 5 years from the date on which he enters upon his office and shall be eligible for reappointment for another term of 5 years. This is, however, subject to the condition that no member shall hold office after he has attained the age of 70 years. Amendment of Section 6. Amendment of subsection 1 and 2 of Section 6 of the Municipal Act. One is in subsection 1 of the section 6 for the words 5 years, the words 3 years shall be substituted. B is after the words whichever is earlier occurring at the end, the words and shall be eligible for reappointment shall be inserted. 2 is 1. In subsection 2 for the words 5 years, the words 3 years shall be substituted. B is the words for another term of 5 years shall be omitted. The result of the above amendment is that the term of chairperson shall be now 3 years instead of 5 years. Further, on ceasing to hold office, a chairperson or a member shall be eligible for further employment under the government or the government of any state. This is indeed a welcome feature of the Act. Such a provision ought to be compulsory in respect of the offices of Speaker of the Lok Sabha, Deputy Speaker of the Rajya Sabha, Chief Election Commission and Governors of States, removal of a member of the Commission. The chairperson or any other member of the Commission can be removed from his office by order of the President on the ground of proved misbehavior or incapacity after the Supreme Court. On reference being made to it by the President has an inquiry held in accordance with the procedure prescribed in that behalf by the Supreme Court reported that the chairperson or such other member as the case may be or on any such ground be removed. But despite the provision or notwithstanding this provision, the President may by order remove from office the chairperson or any other member if the chairperson or such other person, as the case may be, one is adjudged and insolvent, or B is engages during his term of office in any paid employment outside the duties of his office. 3 is, uni- 3 is unfit to continue in office by reason of infirmity of mind or body. 4 is of unsound mind and stands so declared by a competent court. Or 5 is convicted and sent to imprisonment for an offense which in the opinion of the President involves moral turpitude. In the above cases, it will not be necessary for the President to refer the matter to the Supreme Court and obtain its report before ordering the removal of a chairperson or a member. Procedure of the Commission. The Commission shall meet at such time and place as the chairperson may think fit. The Commission shall regulate its own procedure. All orders and decisions of the Commission shall be authenticated by the Secretary General or any other officer of the Commission duly authorized by the chairperson in this behalf. Functions of the Commission. The Commission shall perform all or any of the following functions, namely, one is inquire suo motu or on a petition presented to it by victim or any other person on his behalf into complaint of violation of human rights or abatement thereof or negligence in the prevention of such violation by a public servant. Intervene in any proceeding involving any allegation of isolation of human rights pending before a court with the approval of such cases. Visit under intimidation to the state government, any jail or any other institution under the control of the state government, where persons are detained or lost for purposes of treatment, reformation or protection to study the living conditions of inmates and make recommendations therein. Review the safeguards provided by or under the Constitution or any law for the time being enforced for the protection of human rights and recommend measures for their effective implementation. Review the factors including acts of terrorism that inhibit the employment inhibit the enjoyment of human rights and demand appropriate remedial measures, study treaties and other international instruments on human rights and make recommendations for their effective implementation, undertake and promote research in the field of human rights, spread human rights literacy among various sections of the society, and promote awareness of the guards available for the protection of these rights through publications, the media, seminars, and other available means. Encourage the efforts of non-governmental organizations and institutions working in the field of human rights, and such other functions as it may consider necessary for the promotion of human rights. But there are certain matters which are not subject to the jurisdiction of the Commission. The Commission cannot inquire into any matter which is pending before a state commission or any other commission duly constituted under any law for the time being in force. Besides this, the commission or the state commission shall not inquire into any matter after the expiry of 1 year from the date on which the act constituting violation of human rights is alleged to have been committed. This provision or inhibition of the commission contained in section 36 2 of the act came for consideration before the Supreme Court in Paramjit Court versus State of Punjab. One of the main questions for consideration before the court was whether the inhibition contained in section 36 2 would apply to the commission even when the Supreme Court under Article 32 of the Constitution referred a matter of alleged violation of human rights to the Commission. In NC Thundial versus Union of India, a three-judge bench of the Supreme Court held that Section 36A of the Act thus places an embargo against the Commission inquiring into any matter after the expiry of 1 year from the date of alleged act violative of human rights. The caption or the marginal heading to the section indicates that it is a jurisdictional bar. Periods of limitation, though basically procedural in nature, can also operate as fetters on jurisdiction in certain situations. The language employed in the marginal heading is another indicator that it is a jurisdictional limitation. It is a settled rule of interpretation that the section heading or marginal note can be relied upon to clear any doubt or ambiguity in the interpretation of provisions and to discern the legislative intent. Further, the bar under section 36(2) is sought to be got over by the Commission by invoking the theory of continuing wrong and the recurring cause of action. According to the Commission, every violation of human right is a continuing wrong until and unless due reparation is made. The Supreme Court found it difficult to accept this proposition propounded by the Commission. Speaking for the three-judge bench, P. Venkatraman Reddy J. observed that the short answer to this viewpoint is that such a view, if accepted, makes Section 36(2) practically a dead letter. Moreover, looking to the language employed in Section 36(2) is the concept of continuing wrong could not at all be pressed into service in the instant case. The time limit prescribed is referable to the alleged act constituting the violation of human rights. In a case like illegal detention, the offensive act must be deemed to have been committed when a person is placed under detention and it continues under legal detention. The commission of offensive act is complete at a particular point and it does not continue to be so even after the unauthorized detention ends. In this case, one Mr. Ashok Kumar Sinha, an officer of the telecom department at Ranchi in 3/3/1994, He was arrested and later on produced before the magistrate and remanded to police custody. It was not in dispute that the complainant was produced before the special judge on 3/4/1994 and remand was obtained in accordance with the procedure prescribed by law. The Supreme Court held that the alleged act of unauthorized detention, which gives rise to violation of human rights, ceased on 3/4/1994, and perpetual it does not perpetuate thereafter. It is not the effect of the illegal detention which is contemplated by Section 36(2), but it is the illegal act itself. It would be a contradiction in terms to say that the arrest or detention beyond 3/4/1994 was in accordance with the law, and at the same time the arrest or detention continued to be wrongful. It cannot therefore be brought under the category of continuing wrong, which is analogous to the expression continuing offense in the field of criminal law. 1 year period for taking up the inquiry into the complaint therefore comes to an end by 3/4/1995, just as in the case of Section 473 CRPC. There is no provision in the Act to extend the period of limitation of 1 year. Before concluding the discussion, the Supreme Court said it would like to clarify in reiteration of what was said by the Supreme Court in Paramjit Kaur versus State of Punjab, that in a case where the NHRC proceeds to investigate and inquire into the violation of human rights pursuant to the directions of the Supreme Court under Article 32 of the Constitution, the bar contained in Section 36(2) will not apply because in such an event NHRC does not function under the provisions of the Act but as an expert body, adding the Supreme Court in the discharge of its constitutional power under Article 32, interpreting the order of the Supreme Court. The Commission observed that the shackles and limitations under the Act are not attracted to the Commission, as it in the above context does not function under the provisions of the Act but under the remit of the Supreme Court. The provisions of the Act do not bind or limit the powers of the Supreme Court in exercise of its powers under Article 32. It is therefore reasonable to hold that the Supreme Court designated the Commission as body sui generis to carry out the functions and determine issues entrusted to it by the Supreme Court. To read the order otherwise is to render it otious. Agreeing with the above interpretation of the Commission, the Supreme Court held that the power and jurisdiction of the Supreme Court under Article 32 of the Constitution cannot be curtailed by any statutory limitation, including those contained in Section 36(2) of the Act. If the Supreme Court can exercise that power unaffected by the prohibition contained in Section 36(2), there is no reason why the Commission, at the request of the Supreme Court, cannot investigate or look into the violations of human rights, even though the period of limitation indicated in Section 36. 2 years might have expired in such a situation. The Commission will not be affected by the bar contained in Section 36 2 years, and it will be well within its rights to investigate the matter referred to it by the Supreme Court. Further, in deciding the matters referred by the Supreme Court, National Human Rights Commission is given a free hand and is not circumscribed by any condition. Therefore, the jurisdiction exercised by the National Human Rights Commission in these matters is of special nature, not covered by enactment or law, and thus acts sui generis. The Commission is also a body sui juris created under an act made by Parliament for examining and investigating the question and complaints relating to violation of human rights, as also the negligence on the part of any public servant in preventing such violations. In this case, the writ petition had been filed by the Union of India for clarification of the order dated 12th December 1996, passed by the Supreme Court in writ petition Criminal Laws 447 of 1995 and 497 of 1995, by which a request was made to the National Human Rights Commission to examine the flagrant violation of human rights on a mass scale in the state of Punjab as disclosed in CBI reports submitted to the Supreme Court in the aforesaid writ petitions. Powers relating to inquiries. While inquiring into complaints under this Act, the Commission possesses all the powers of a civil court trying to suit under the Code of Civil Procedure 1908, 5 of 1908 in the particular in respect of the following matters, namely: one is summoning and enforcing the attendance of witnesses and examining their oaths. Two is discovery and production of any document. Three is receiving evidence and affidavits. Four is requisitioning any public record or copy thereof from any court or office. Five is issuing commission for the examinations of witnesses or documents. Six is any other matter which may be prescribed. The Commission also has power to require any person subject to any privilege which may be claimed by that person under any law for the time being in force, to furnish information on such points or matters as, in the opinion of the Commission, may be useful or relevant to the subject matter of the inquiry, and any person so required shall be deemed to be legally bound to furnish such information within the meaning of sections 176 and 177 of the Indian Penal Code 45 of 1860. The Commission or any other officer not below the rank of a gazetted officer, especially authorized in this behalf by the Commission, may enter any building or place where the Commission has reason to believe that any document relating to the subject matter of the inquiry may be found, and may seize any such document or take extracts or copies therefrom, subject to the provisions of Section 100 of the Code of Criminal Procedure 1973, 2 of 1974, insofar as it may be applicable. It is also provided that the Commission shall be deemed to be a civil court, and when an offence, as is described in sections 175, omission to give notice or information to public servant by person legally bound to give it. Section 178, Section 179, Section 180, or Section 288, 228 of the Indian Penal Code 45 of 1860 is committed in view of presence of the Commission. The Commission may, after recording the facts constituting the offence and statement of the accused as provided for the Code of Criminal Procedure 1973, 2 of the 1974, forward the case to a magistrate having jurisdiction to try the same, and the magistrate to whom any such case is forwarded shall proceed to hear the complaint against the accused as if the case has been forwarded to him under section 346 of the Code of Criminal Procedure 1973. Further, every proceeding before the Commission shall be deemed to be a judicial proceeding within the meaning of Section 193, 228 and for the purposes of Section 196 of the Indian Penal Code 45 of 1860, and the Commission shall be deemed to be a civil court for all the purposes of Section 195, which deals with persecution for contempt of lawful authority of public servants for offences against public justice and for offences relating to documents given in evidence, and Chapter 26 of the Code of Criminal Procedure 1973 to of the 1974. In K. Mrudugesh versus Registrar State Human Rights Commission, Tamil Nadu, and others, the Madras High Court observed that it is clear from the above provision that the Commission has been given the power of a civil court in certain matters, while it inquires into any complaint under the Act. In the instant case, the Sub-Inspector of Police was given an opportunity to cross-examine complainant in respect of his complaint. The Madras High Court ruled that there was not any fairness on the part of the Commission in adopting the said procedure whereby the petitioner is given an opportunity to cross-examine the complaints. The court further added that it is obvious that the inquiry before the Commission cannot be equated with the full-fledged civil trial under the Code of Civil Procedure. From the pursuit of Section 13 of the Act, it is clear that what the Commission had to follow is a fair procedure. In the instant case, the petitioner was given an opportunity to cross-examine the complainant on the basis of those complaints. Following the aforesaid procedure, the Commission was only giving the writ petitioner an opportunity to cross-examine. So, by giving an opportunity to the petitioner, the Commission cannot be said to have acted unfairly against the interest of anyone. Investigation. The Commission may, for the purpose of conducting an investigation pertaining to the inquiry, utilize the services of any officer or investigation agency of the central government or any state government with the concurrence of the central government or the state government, as the case may be, for the purpose of investigating into any matter pertaining to the inquiry. Any officer or agency whose services are utilized under Section 14.1 noted may subject to the direction and control of the Commission. One is summon and enforce attendance of any person and examine him. Two is require the discovery and production of any document. Three is requisition any public record or copy thereof from any office. But it may be noted here that no statement made by a person in the course of giving evidence before the Commission shall subject him to, or be used against him in any civil or criminal proceeding, except or prosecution for giving false evidence by such statement. This is, however, subject to the proviso that if the statement is made in reply to a question which he is required by the Commission to answer or is relevant to the subject matter of the inquiry, then it may be used against him in any civil or criminal proceeding. As regards examination of witness, in Jahira Habibullah versus State of Gujarat, the witness stated that she was threatened, coerced, induced, and or pressurized to give statement before trial court, National Human Rights Commission and Supreme Court. An inquiry was made to find out truth. The statement of witness was recorded by National Human Rights Commission in the presence of Chairman, retired Chief Justice of Supreme Court and several members, which included retired Judge of Supreme Court. An allegation was made that it was not properly recorded and that somebody else's statement was recorded and witness was asked to put signature. The Supreme Court held that this was not tenable. Further, the Supreme Court added that such a plea should not have been raised as it reflects credibility of functioning of body like National Human Rights Commission. The officer or agency whose services are utilized under Section 14.1 One is noted above shall investigate into any matter pertaining to the inquiry and submit a report thereon to the Commission within such period as may be specified by the Commission in this behalf. The Commission shall satisfy about the correctness and the facts stated in the conclusion. If arrived at the said report submitted by the officer or agency, and for this purpose the Commission may make such inquiry, including the examination of the person or persons who conducted or assisted in the investigation as it thinks fit. Procedure for dealing with complaints. Regulation 8 of the National Human Rights Commission Procedure Regulations 1994 lays down the following procedure for dealing with complaints of alleged violation of human rights. All complaints in whatever form received by the Commission shall be registered and assigned a number and placed for admission before a bench of two members constituted for the purpose not later than 2 weeks of receipt thereof. Ordinarily, complaints of the following nature are not entertainable by the Commission. One is in regard to the events which happened more than 1 year before the making of complaints. Two is with regard to matters which are sub judice. Three is which are vague, anonymous, or pseudonymous. Four is which are of frivolous nature, or five is which those which are outside the purview of the Commission. No fee is chargeable on complaints. Every attempt should be made to disclose a complete picture of the matter leading to the complaint, and the same may be made in English or Hindi to enable the Commission to take immediate action to facilitate the filing of the complaints. The Commission shall, however, entertain complaints in any language included in English the schedule of the Constitution. It shall be open to the Commission to ask for further information and affidavits to be filed in support of allegations whenever considered necessary. The Commission may, in its discretion, accept telegraphic complaints and complaints conveyed through fax. The Commission shall have the power to dismiss a complaint in limine. Upon admission of a complaint, the chairperson or commission shall direct whether the matter would be set down for inquiry by it or should be investigated into. And every complaint on which a decision is taken by the chairperson or commission to either hold an inquiry or investigation, the secretariat shall call for report or comments from the concerned government or authority, giving the latter a reasonable time therefor. On receipt of the comments of the concerned authority, a detailed note on the merits of the case shall be prepared for consideration of the Commission. The directions and the recommendations of the Commission shall be communicated to the concerned government or authority and the petitioner as provided for in Section 18 and 19 of the Act. The Commission may, in its discretion, afford a personal hearing to the petitioner or any other person on his behalf, and such other person or person as in the opinion of the Commission should be heard for appropriate disposal of the matter before it, and where necessary call for records and examine witnesses in connection with it. The Commission shall afford a reasonable hearing, including opportunity of cross-examining witnesses, if any, in support of the complaint, and leading of evidence in support of his stand to a person whose conduct is inquired into by it, or where in its opinion the reputation of such person is likely to be prejudicially affected, where investigation is undertaken by the team of the Commission or by any other person under its discretion. The report shall be submitted within a week of its completion of such further time as the Commission may allow. The Commission may, in its discretion, direct further investigation in a given case if it is of the opinion that investigation has not been proper or the matter requires further investigation for ascertaining the truth or enabling it to properly dispose of the matter. On receipt of the report, the Commission on its own motion or if moved in the matter, they direct inquiry to be carried by it and receive evidence in course of such inquiry. The Commission or any of its members, when requested by the chairperson, may undertake visits for an on the spot study, and where such study is undertaken by one or more members, a report thereon shall be furnished to the Commission as early as possible. Steps after inquiry. After the inquiry under the Act is complete, the Commission may take any of the following steps. 1A. Where the inquiry discloses the commission of violation of human rights or negligence in the prevention of violation of human rights by a public servant, it may recommend to the concerned government or authority the initiation of proceedings for prosecution or such other action as the Commission may deem fit against this concerned person or persons. Two is approach the Supreme Court or the High Court concerned for such direction, orders or writs as that court may deem necessary. Three is recommend to the concerned government or authority for the grant of such immediate interim relief to the victim or the members of his family as the Commission may consider necessary. Four is subject to the provisions of clause 5. Provide a copy of the inquiry report to the petitioner or his representative. 5 is the Commission shall send a copy of its inquiry report together with its recommendations to the concerned government or authority, and the concerned government authority shall, within a period of 1 month or such further time as the Commission may allow, provide its comments on the report, including the action taken or purpose to be taken thereon to the Commission. 6 is the Commission shall publish its inquiry report together with the comments of the concerned government or authority, if any, and the action taken or proposed to be taken by the concerned government or authority on the recommendations of the Commission. Regulation 11 of the National Human Rights Commission Procedure, Regulations 1994, further provides that report of follow-up question shall be submitted to the Commission at every subsequent sitting, indicating therein the present stage of action on each item on which the Commission had taken a decision in any of its earlier meeting, excepting the items on which no further action is called for. Procedure with respect to armed forces, Section 19 of the Protection of Human Rights Act 1993 provides, notwithstanding anything contained in this act, while dealing with complaints of violation of human rights by members of armed forces, the Commission shall adopt the following procedure, namely, one is it may, either on its own motion or on receipt of a petition, seek a report from the central government. Two is, after the receipt of the report, it may either not proceed with the complaint or, as the case may be, make its recommendations to that government. The central government shall inform the Commission of the action taken on the recommendations within 3 months or such further time as the Commission may allow. The Commission shall publish its report together with its recommendations made to the central government and the action taken by the government on such recommendations. The Commission shall provide a copy of the report published under subsection 3 of the petitioner or his representatives. Matters beyond the jurisdiction of National and State Human Rights Commission. National Human Rights Commission cannot go moto take action against a judicial order. Recommendations by National Human Rights Commission to continue to commute death sentence passed by Supreme Court is non-East in law. This has been held by the Supreme Court in Venkatas Das versus State of Assam, the Supreme Court set aside the impugned order of the commutation of death sentence to life imprisonment and directed recommendation of application filed by accused for commutation of sentence. Similarly, the Commission cannot assume the jurisdiction of High Court and Supreme Court and cannot proceed to arrogate to itself powers under Section 482 of CRPC of Article 226. This has been held by Punjab and Haryana High Court in Punjab State Civil Suppliers Corporation Limited versus Punjab Human Rights Commission. In this case, FIRs were registered against the respondents for forcibly lifting stock of paddy. The State Human Rights Commission recommended cancellation of FIRs on complaint filed by respondents. The Punjab and Haryana High Court held that the order was passed in flagrant disregard of statutory powers. The impugned order of Commission recommending cancellation of FIRs is liable to be quashed. Annual and special reports of the Commission. The National Human Rights Commission is required to submit an annual report to the central government and to the state government concerned and may at any time submit special reports on any matter which in its opinion is of such urgency or importance that it should not be deferred till submission of the annual report. After the annual report is submitted by the Commission, the central government and the state government, as the case may be, shall cause the annual and special reports of the Commission to be laid before each House of Parliament or the state legislature respectively. As the case may be, along with a memorandum of action taken or proposed to be taken on the recommendations of the Commission and the reasons for non-acceptance of the recommendations, if any. A high-level advisory committee under the chairmanship of Mr. Justice A.M. Ahmadi, former Chief Justice of India, to assess the need for structural changes and amendments to the Protection of Human Rights Act. The advisory committee submitted its report to the Commission on 18th October 1999. After careful consideration of it in detail, the Commission sent its report to the government in March 2000. Among the several recommendations, one recommendation was to prescribe 3 months' time from the date of the submission of the report of the National Human Rights Commission (NHRC) to be placed before the Parliament and reports to be made public after 3 months. Even if not placed before the Parliament, the central government has not acted on these recommendations. Thus, the suggested amendment in Act has yet not been made. Thus, no period has been fixed for tabling of the annual and special reports of Commission before the Parliament. Thus, the central government is to a great extent responsible for the present situation of human rights in the country. The Commission is not sufficiently equipped to investigate and ensure respect for and observation of human rights in the country. The delay in tabling the reports of the NHRC before the Parliament shows that the government is not serious about the recommendations of the Commission and action on such recommendations. It may be noted that mostly poor people are the victims of violation of human rights. Though the government claims to be the champion of the rights of poor peoples, there is great difference between what the government says or proclaims and what in fact it does. If the government is really serious and keen for the rights of common people, especially poor people, it should accept the recommendations of the Commission and amend Protection of Human Rights Act so that after the submission of the annual reports, if the government fails to table the report before the parliament within 3 months, it after the expiry of 3 months since the submission of the report, the Commission may make the annual report public and may publish it. Evaluation of the work of the National Human Rights Commission. The National Human Rights Commission has rendered a signal for service for the cause of observance of human rights, especially in the field of civil liberties. Especially in the field of civil liberties, for example, its work in the field of prevention of custodial deaths, rape and torture has been quite praiseworthy. Its direction to all district magistrates and superintendents of police to report to the Commission all incidents of custodial death or rape within 24 hours has made a very salutary impact in preventing such incidents. Moreover, it is a sort of forewarning to the police officers that if they misuse their powers or commit excesses, they may be penalized for this. Besides this, the Commission has handled some cases of alleged custodial death in such an effective manner that it has inspired the confidence of the people. For example, in the case of alleged custodial death of Madan Lal in Delhi, the Commission took cognizance of this case, motto and appointed Shri Ramsi Chopra, a member of Higher Judicial Service, to investigate the matter. The report dated 11th March 1994, submitted by Mr. Chopra, inferred that Shri Madan Lal had died as a result of a physical assault on his person while he was in custody within a police station, for which an assistant sub-inspector and three constables were held prima facie responsible. The Commission accepted this report and recommended to the NCDT infer alia. The investigation of the case be handed over to the CBI. Department action against the ACSI. Department action against the ASI of the police station concerned be taken and interim compensation of rupees 59,000 should be paid to the dependents of the deceased within 1 month without prejudice to the compensation that may be claimed in accordance with law. Subsequently, that is on 30th May 1994, the government of the NCDT conveyed its acceptance of the recommendation of the Commission. It cannot but be considered that the Commission has no teeth and it can take no action directly. It can only recommend and the government may or may not accept its recommendation. This position is far from satisfactory in a country where the government can make or give excuses and can express difference of opinion in respect of the implementation of the report of the Joint Parliament Committee with regard to bank security scam. The recommendations of the Commission are not sufficient and the government can anytime for political or other reason avoid to implement the recommendation of the Commission or may not pay serious heed to it. The powers given to the Commission under Section 18 after completion of an inquiry are just insufficient. Thus, there is much force in the criticism that the Commission has no teeth and it can only make recommendation. Its recommendations are not binding on the government or the authority concerned. However, it may be noted that even though the Commission can neither render a decision like a court nor can its decisions be enforced like judgments, yet it would not be correct to say that the National Human Rights Commission is a weak or impotent body. Headed by a former Chief Justice of India and consisting of judges of Supreme Court and Chief Justices of High Courts. Its recommendation commands great respect. It is a statutory autonomous body and derives its power and authority Common Act of Parliament. The central or state government will have to think several times before deciding to avoid or refuse to implement the recommendations of such an august body. It also deserves mention here that under section 18(6) it is mandatory for the Commission to publish its inquiry report together with the comments of the concerned government or authority, if any, and the action taken or proposed to be taken by the concerned government or authority on the recommendations of the Commission. Such report, when published, creates a strong public opinion. Obviously, no government in a democratic country like ours can afford to resist or avoid such public opinion. Therefore, instead of being reluctant or repulsive, the government will be too willing to accept and implement the recommendations of the Commission. Yet another point to be noted here is the narrow definition of human rights given under the Act. It limits human rights to only the rights relating to life, liberty, equality, and dignity of the individual guaranteed by the Constitution. The Commission had recommended amendments of Protection of Human Rights Act 1993, but it is disheartening to note that the Indian government did not pay proper heed to it. Now the government has changed, and the present coalition government headed by Congress may again take considerable time to do the needful. This definitely limits the scope of the Commission to ensure the observance of human rights. However, the redeeming feature is found in the words are embodied in the international covenant and enforceable by courts in India. Even though these words are also qualified by words, rights relating to life, liberty, equality, and dignity of the individual. They certainly widen the scope of the human rights about the observance or the observation of which the Commission will have jurisdiction. This is because of the fact that the Supreme Court has recognized a number of separate and independent fundamental rights as being either part of the existing fundamental right or rights or emanating from them. Moreover, the Supreme Court has recognized in a number of cases referred to earlier that international conventions, international conventions on human rights can be used in interpreting the constitutional provisions, and one or more existing fundamental rights are of the wide amplitude to include the provisions of international convention. They can be read into the existing fundamental rights. Thus, new fundamental rights such as right to gender equality and prohibition of sexual harassment of working women at their places of work can be recognized in future by the Supreme Court. Thus, it may be concluded that despite several shortcomings and drawbacks in the Act, the Commission in practice has proved to be an effective body for the observance of human rights in the country. Within a short period, that is only a few years, it has performed creditable and praiseworthy works. It has rendered a signal service for the observance of human rights, especially in the field of custodial violation, custodial violence and deaths, false encounters by police, abuse or misuse of powers by police officials, rape cases, review of acts and statutes such as Terrorist and Disruptive Activities Prevention Act 1987, TADA, and Prevention of Terrorism POT Bill 2000. Most of the recommendations of the Commission have so far been accepted. If some of its recommendations have not so far been accepted and acted upon, the fault is not of the Commission but lies somewhere else, that is, with the concerned government or authority. It is therefore desirable that the central or the state government should pay serious heed to the recommendation of the Commission, and unless there are some very strong or cogent reasons for not accepting the recommendation, the government should generally accept and promptly implement the recommendations of the Commission. State Human Rights Commission. According to Section 21, one of the Protection of the Human Rights Act 1993, a state government may constitute a body to be known as the name of the State Human Rights Commission to exercise the powers conferred upon and to perform the function assigned to a state commission under Chapter 5 of the Act. The wording of this provision, especially the word may, indicate that it is not compulsory for the states to establish state human rights commission. Thus, it depends upon the discretion of the state. While under Section 3 of the Act, it is compulsory and mandatory for the central government to constitute a body to be known as the National Human Rights Commission. For Section 3 uses the words shall constitute. It is simply optional under Section 21 for the state to constitute a state human rights commission. This is a great defect and weakness of the Act, since most of the violation of human rights take place in state territories. It should have taken compulsory and mandatory for the states to establish State Human Rights Commission. It is because of this flaw in the Act that many states have yet not established the State Human Rights Commission. Only a few states, namely West Bengal, Assam, Madhya Pradesh, Tamil Nadu, and Himachal Pradesh, have so far established the State Human Rights Commission by the end of March 1997. Subsequently, the government of Punjab state has established such a commission, but Uttar Pradesh has simply notified the constitution of a state commission. Later on, the example of above mentioned states has been followed by the government of Jammu and Kashmir. In its annual report of 1995 to 96, the National Human Rights Commission (NHRC) has recommended that state commission be established at an early date in the remaining states also. The Commission has therefore recommended that it should be mandatory for every state to establish State Human Rights Commission. So far, State Human Rights Commission have been set up in 18 states. The names of these states are Andhra Pradesh, Assam, Bihar, Chhattisgarh, Gujarat, Himachal Pradesh, Jammu and Kashmir, Karnataka, Kerala, Madhya Pradesh, Maharashtra, Manipur, Odisha, Punjab, Rajasthan, Tamil Nadu, Uttar Pradesh and West Bengal. The NHRC is keen that State Human Rights Commission SHRCs are set up in all the states so that each and every citizen of the country has every recourse to better protection of human rights as well as for better connected therewith or incidental thereto. The Commission earnestly recommended to all those states which have not yet constituted SHRCs to follow suit at the earliest in the interest of better protection and promotion of human rights. Constitution of State Human Rights Commission. The State Human Rights Commission shall consist of a chairperson who has been a Chief Justice of a High Court, one member who is or has been a judge of a High Court, one member who is or has been a district judge in that state, two members to be appointed from amongst persons having knowledge of or practical experience in matters relating to human rights. The Act also makes provision for the appointment of a secretary who shall be the chief executive officer of the state commission and shall exercise such power and discharge such functions of the state commission as it may delegate to him. As regards of the district judge to be appointed, it may be noted that Act 43 of 2006 enacted by Parliament provided that a district judge who is to be appointed should also possess and experience that of the district judge of 7 years in J.S. Yadav versus State of UP. Under the provisions of amended Act, state government had proceeded to reconstitute the commission and had simultaneously issued notification stating that petitioner had ceased to hold office on account of amended provisions because of the petitioner was additional district judge who acted as district judge and had the experience for such period would not be counted to come under definition of district judge. The division bench of the High Court observed that Reading of the amended act, intention of the legislature that the post ought to be filled by a High Court judge. The legislative intent is to exclude one on account of experience. Court cannot examine such intent but to honor. Human rights approach is human right approach is equitable in nature and flows from the principle of natural justice for which High Court judges are more comfortable in discharging the duties conceived of. Headquarters of the State Commission. The headquarters of the State Commission has not been fixed or settled by the Act. It should have been at the state capital like that of NHRC, which is at national capital. It has been left to the discretion of the state government to fix or settle the place. The Act simply provides that it shall be at such places as the state government may, by notification, specify. Jurisdiction of the State Commission. Subsection 5 of the Section 21 provides that a State Commission may inquire into violation of human rights only in respect of matters relatable to any of the entries enumerated in List 2 and List 3 in the 7th Schedule to the Constitution. This is, however, subject to proviso that if any such matter is already being inquired into by the Commission, that is NHRC, or any other commission duly constituted under any law for the time being in force, the State Commission shall not inquire into the said matter. But according to the second proviso in relation to Jammu and Kashmir Human Rights Commission, this subsection, that is subsection 5 of the section 21, shall have effect as if that the words and figures list 2 and list 3 in the 7th schedule to the Constitution. The words and figures list 3 in the 7th schedule to the Constitution as applicable to the state of Jammu and Kashmir in respect of matter in relation to which the legislature of that state has power to make laws had been substituted. The territorial jurisdiction of the National Human Rights Commission or the Commission has not been specifically mentioned or clarified in any provision of the Act, although the words of Section 12 in general indicate and imply that it extends to the whole territory of India. However, negatively, Article 36 1 is curtains the jurisdiction by providing that the Commission shall not inquire into any matter which is pending before State Commission for State Commission or any other commission duly constituted under any law for the time being in force. Besides this, Section 36(2) provides that both of the Commission and the State Commission shall not inquire into any matter after the expiry of 1 year from the date on which the act constituting violation of human rights is alleged to have been committed. The Commission has also recommended amendment of Article 36. As regards Article 36(1), the Commission has recommended that the Commission should be allowed to inquire into an matter, notwithstanding the matter may be pending before a State Commission or other commission except on inquiry commission established under Commission of Inquiry Act. As regards Article 36(2), the Commission has recommended that it should be entitled to inquire into any matter even though 1 year has elapsed. Thus, it is certain that a State Commission cannot inquire into violation of human rights in respect of matters relatable to any of the entries enumerated in List 1. This is clear from subsection 5 of Section 21 of the Act, where the National Commission may inquire into violation of human rights only in respect of matters related to any of the entries enumerated in List 1 also, but also in respect of entries enumerated in List 2 and List 3. Thus, there are chances of conflict between the jurisdiction of the Commission or State Commission, but there is no provision for coordination of activities of both the Commission, nor there is any provision for the resolution of conflict if any arises. That should have made clear provisions in this respect. I think yet another vague provision in this respect is the use of the words or any other commission duly constituted under any law for the time being enforced. This provision can be misused by the central or state government by constituting a commission under any other law for the time being enforced to oust the jurisdiction of the commission or state commission so as to keep it away from serious cases of alleged violation of human rights for political or other reasons. The commission has done commendable works during a brief period of 9 years. If the Commission is facing certain problems in pertaining in performing its task of better protection of human rights assigned to it, it is the duty of the government to solve them. Sooner the government performs its duty, the better. The appointment of a committee of joint secretaries, which has held 4 meetings, each after a gap of 4 to 6 months, and has yet to finalize its report, is not the proper way for the democratic government to perform its duty. By adopting such an attitude, the government is obstructing the work and progress of the Commission. The democratic government ought to endeavor to play the role of guarantor and protector of human rights. This can be done by assisting and helping the NHRC by acting on its recommendations rather than obstructing and delaying things. I thank all my brothers and sisters, ladies and gentlemen, students, scholars, teachers, trainers, professors, professionals, officer, official, listener, learners. I thank all listeners, those who are listening, YouTube channel 3M creator. Time and again, I thank all of you.